Welcome back, everyone. The topic for this session is Taming the Unruly Horse, Public Policy in International Arbitration, India, UK, and Singapore. May I request the chair and the panelists for this session to please come onto the stage. Please. This session will bring to light rather an unpredictable concept of public policy being interpreted and applied in 3 different jurisdictions, UK, Singapore, and India, which have often taken a starkly different approach to the process and concept of public policy. The session will be discussion on decisions on these jurisdictions that have extended much clarity on the far-reaching concepts of the fundamental principle of public policy. This session will be chaired by Honorable Mr. Justice Ravindra Bhat. Honorable Justice Bhat is a judge of the Supreme Court of India since 2019. Before his elevation, he was appointed as the Chief Justice of the High Court of Rajasthan. He enrolled as an advocate with the Delhi Bar Council in 1982 and practiced in the Supreme Court, where he was enrolled as an advocate on record in 1989. Before his elevation to the bench, he practiced in public law, employment, education, and constitutional disputes, and appeared in several important cases before constitutional benches of the Supreme Court. With him, we have the gracious presence of Honorable Dr. Justice Mr. Muralidhar. Justice Muralidhar is the Chief Justice of Orissa High Court. He is a former judge of the Punjab and Haryana High Court. He was initially appointed as a judge of the High Court of Delhi in May 2006. During his almost 14-year stint as a judge of the High Court of Delhi, he pronounced various landmark judgments dealing with a variety of issues. He began his law practice in Chennai in 1984. He qualified the Advocate on Record examination in 1990. He was also an active lawyer for the Supreme Court Legal Services Committee and later on was its member for 2 terms. He was appointed amicus curiae by the Supreme Court in several public interest litigation cases and in cases involving convicts on death row. Sharing the dice with him is Mr. Darius Khambata, senior advocate who was called to the bar in India in 1984. He was designated as senior advocate in 2005. He practices before the Supreme Court of India, the Bombay High Court, and other high courts and tribunals across India. He has held 2 distinguished public law offices, Advocate General for Maharashtra and Additional Solicitor General of India in the past. He was also the Vice President of LCIA Court and is currently a member of SIAC Court. Moving on to Mr. Vernon Flynn. He is an English silk with a global arbitration practice operating from Briggs Court Chamber in London. He appears in arbitrations across. May I now request the chair to please come forward and share his views with all of us.
Good morning to all of you, my panelists, Mr. Justice S. Muralidhar, Chief Justice of the Orissa High Court, Mr. Vernon Flint, KC of Brick Court, Mr. Darius Khambata, Senior Advocate, Judges of Delhi High Court and various other high courts, members of the bar, ladies and gentlemen. Burrow J. used this term, which has almost become an aphorism, that public policy is an unruly horse. He said that public policy is a very unruly horse, and when you get astride, you never know where it will carry you. This was said in 1824, and we are still grappling with that unruly horse almost 200 years later. Whether you call it taming it or saddling it, we have not yet been able to reach a consensus, and I suspect we can never do that. The language of Article 5.2b of the New York Convention, redrafted several times by the working group, ultimately provided that the enforcing court could refuse enforcement if it found that the recognition or enforcement of the award would be contrary to the public policy of that country. Now, that country refers to the place where recognition and enforcement is claimed. The intent of the provision therefore points to a national public policy, the public policy of that country, of the enforcing court. This is the necessary interpretation because the purpose behind the exception was to permit a country to refuse and to enforce an award that was contrary to its own system. Courts have used differing interpretations of this exception in the national and international contexts. The convention does not define public policy, perhaps advisedly so. Therefore, the public policy of one country will not exactly be the same as of another. Existence of different standards in countries highlights their national public policy, and these can result in quite different interpretations of that term. In addition, public policy is also relative. It is time sensitive and it may also continue to evolve. Yet, there are some common principles which have emerged, securing the public policy exception from becoming what a famous judge said in another context, the key that unlocks a door that otherwise should be shut. Fostering convention enforcement and have encouraged courts not to refuse enforcement based on broadly defined domestic standards. Lord Atkins said in this context, and it's another very famous quotation, that public policy should only be invoked in clear cases in which the harm to the public is substantial and incontestable and does not depend upon the idiosyncratic inferences of a few judicial minds. The high threshold of what is public policy can be seen from the way it is perceived in both common law and civil law jurisdictions. In France, it is known as the body of rules and values whose violation the French legal order cannot tolerate, even in situations of international character. In India, it is recognized as something that must amount to a breach of some legal principle or legislation, which is so basic to Indian law that it is not susceptible of being compromised. Fundamental policy refers to the core value of India's public policy as a nation, which may find expression not only in statutes, but also time-honored, hallowed principles which are followed by the courts. In Singapore, the standard has been described as one where the award must offend against our basic notions of justice and morality, or there must be exceptional circumstances to justify a refusal of enforcement. I don't want to speak more because we have three very distinguished speakers. The method we follow in this panel is that each speaker would give his views for about 15 to 20 minutes, after which we would explore the subject through a panel discussion, and then, time permitting, we will throw open the floor for questions from the audience. So without further ado, I would request Mr. Vernon Flynn to speak on the historical context of public policy, a comparative analysis of UK, India, and Singapore. Mr. Flynn, you can sit there and continue to speak. I'll join you there.
Thank you. Before I begin, I'd just like to say that it's always a pleasure to be in India, but it's a particular pleasure to be here at what seems to be, in the words of the Chief Justice, an inflection point for Indian arbitration. What an amazing Chief Justice India has, and what a golden future in the world of international arbitration. Although today most states adopt what is referred to as a pro-arbitration policy, over the centuries different states have adopted different approaches to arbitration. Some states have at times found arbitration threatening to its sovereignty, and at other times, like today, most states have embraced arbitration. And there's been a growth not just in disputes, but also in the scope of the disputes which are considered arbitrable. But all states have limits on what can properly be arbitrated and what is not arbitrable, crimes being the obvious example. But arbitrability dovetails with public policy when it comes to enforcement. In the context of international arbitration, public policy was introduced as a ground to refuse the recognition and enforcement of foreign arbitration awards by the 1927 Geneva Convention. The convention didn't define public policy and left it to the discretion of the national courts. The 1958 New York Convention, which is the most widely adopted international instrument on arbitration, also adopted public policy as a ground to refuse enforcement, but added the word international to indicate that a more liberal and flexible approach should be taken by the courts. But the meaning and scope of public policy, and especially international public policy, has not been clearly defined or agreed upon by courts or tribunals. Different jurisdictions have different approaches and standards. Sometimes even within the same jurisdiction, there may be inconsistencies and contradictions. At its core, public policy can be seen as a limit to the autonomy of the parties and the arbitrators, as well as a safeguard for the interests of the state and the international community. It is uncertain because it's not defined and not easily capable of definition, and is thus often a source of uncertainty and inconsistency. And one of the main challenges in the application of public policy is to strike a balance between the respect for autonomy and finality of arbitration and the protection of the essential values and interests of the state and the international community. And different courts may have different views on where to draw the line and how much deference to give to the arbitral tribunals. Some courts adopt a more interventionist approach and use public policy as a tool to review the merits of the award or to protect the interests of the local parties or of the state itself. Other courts adopt a pro-arbitration approach and use public policy as a narrow and exceptional ground and only intervene where there is a clear violation of the fundamental principles of justice or morality. Now, I can't speak with any authority on Indian law or the approach taken by the Indian courts. There are others here who can speak more authoritatively on that, and indeed on Singaporean law. I can only speak with some knowledge of English law, but as we have no Singaporean lawyer on the panel, I'll do my best at the risk of being corrected by the audience. English law adopts a pro-arbitration approach to public policy. And what does a pro-arbitration approach mean in this context? The golden rule is that courts are there to support and not to usurp or undermine arbitration. And whilst easily stated, like many simple rules in life and law, it's not always easy to apply in practice. The core difficulties arise where there's a clash of policies, and very difficult issues can arise in the resolution of those issues, even applying that golden rule to support the arbitration. And there are many examples of such issues. How does one resolve issues of fraud, which is said in common law jurisdictions to unravel everything? Can it unravel an award, and if so, how and when? And what if fraud is raised before the tribunal and dealt with, and what if it is not, but could have been? How does one deal with the doctrine of separability and substantive jurisdiction, which is properly understood as a rule of policy rather than strict logic? In what circumstances should an arbitration clause not be recognised? Those are very difficult issues to resolve in a uniform way. The public policy exception to the enforcement of awards stems from Article 5(2)(b) of the New York Convention, and that permits contracting states to refuse to enforce awards where the recognition or enforcement of the award would be contrary to the public policy of that country. Again, the New York Convention doesn't define public policy, and it allows member states a wide latitude to apply this exception as and how they see fit. It's essentially an attempt to balance the competing interests of party autonomy and the sovereign interests of states. The approach to public policy exception has been jurisdiction-specific, and no one consistent position is involved, which is compounded by the nebulous nature of public policy itself, even as a domestic concept. Most states today take a pro-enforcement stance, but Others do not, and Professor Bourne has said that Article 5.2b can be characterised as an escape device, allowing contracting states to rely on local law to deny parties the recognition of an award. Now, in England, the legal framework for the enforcement of foreign arbitral awards is the Arbitration Act 1996. In particular, Section 103.3 provides that the recognition or enforcement of a New York Convention award may be refused if it be contrary to public policy to recognise or enforce the award. And that is English public policy. But English law has consistently adopted a strict and narrow approach to the public policy challenges. And as a starting point, English courts have recognised there is a public policy in favour of the enforcement of New York Convention awards. In IPCO and NMPC, it was observed by the Court of Appeal that Section 103 was not intended to furnish an open-ended escape route for refusing enforcement of New York Convention awards. In Carpatsky Petroleum and NUCONAFTA, it was said that Section 103 of the Act reflects and embodies the predisposition in favour of enforcing New York Convention awards that runs through the New York Convention itself. And that is a very important starting point. There's no definition of public policy under English law, and English courts have observed that considerations of public policy can never be exhaustively defined. It's been generally considered that the public policy exception should be narrowly defined, approached with extreme caution, and treated as a safety valve, which may only be invoked in a clear case. And it's been said that the public policy exception may typically only be successfully applied where there is some element of illegality, or where the recognition or enforcement of a foreign award would be clearly injurious to public good, or wholly offensive to ordinary, reasonable, and fully informed members of the public. And that's very important because there is a bar, but the bar is a very, very high one. One of the main areas of controversy has been in respect of the public policy exemption on the issue of whether it be contrary to English public policy to enforce a foreign arbitral award where the underlying agreement between the parties is either illegal or itself contrary to English public policy. And in such circumstances, although the court is ultimately concerned with the award itself rather than the underlying contract, it is generally open, at least to the court, to take into account the underlying agreement. The most famous example of this is a very unusual case called Soleimani and Soleimani. There, the plaintiff illegally purchased and exported carpets from Iran to be sold by the defendant, and a dispute arose in respect of the proceeds which arose from those sales. The parties agreed to arbitrate for a Jewish rabbinical Beth Din, which issued an award applying Jewish law, and the defendant applied to set aside the award on the basis that it would be contrary to English public policy to enforce an award founded on an illegal contract. The English courts refused to enforce the award on the basis it had been clearly tainted by illegality, observing that the award reflects on its face an illegal object to the enterprise, which the English court views as contrary to public policy. And it's been said that English law and public policy would not recognise or enforce an arbitration agreement between highwaymen as to how they would divide their spoils. But Soleimani and Soleimani is a very unusual case because on the face of the award it was illegal, yet under the governing law there was no issue with that. In the English famous cases that followed were Westacre and Honeywell, but the most recent case comes from a judge, Mrs. Justice Cockerell, who is a formidable and foremost exponent of arbitration, who practiced in that area. She gave a judgment in a case called Alexander Brothers and Alstrom. Now, in that case, the parties entered into a number of consultancy agreements in relation to various railway projects in China. The defendants had only made partial payments in respect of 3 of those consultancy agreements, and the claimant brought arbitral proceedings for the unpaid sums. The defendants said that the claimants engaged in bribery and corruption and refused to pay those sums on the basis that payment would expose them to a risk of criminal liability. Nevertheless, an award was handed down against the defendants, and they argued before the English court that enforcement would be contrary to Section 103, as the underlying agreement was tainted by illegality. Mrs. Justice Cockerell refused to set aside the award, and she held, and which reflects the current position in England, where the arbitration agreement has jurisdiction to determine the question of illegality and made a determination to the contrary, there was very nearly no scope for the court to reopen the issue of illegality, though it remains conceptually possible that it might be done in exceptional circumstances. In other words, a truly exceptional safety valve. And she also held that the basis for the court's approach of nearly always refusing to revisit an issue decided by the foreign tribunal is primarily grounded in the very great importance given to respecting the decision of international arbitration tribunals and foreign courts, taken together with a public policy in favour of finality, and that there were also practical issues delimiting when an inquiry should be made. It's clear from that the approach of the English courts has consistently been a pro-enforcement one, with the public policy exception engaged only in very limited and exceptional circumstances, such as where the contract is illegal on its face, and that had been expressly recognised by the tribunal, such as in Solomon. And the courts are now very reluctant to reopen the findings of a tribunal, whether as a matter of fact or a matter of law. The approach in Singapore is very similar. Under the International Arbitration Act 1994, the court may refuse to enforce the award if it finds that the enforcement of the award would be contrary to the public policy of Singapore. And the Singapore court's approach to the understanding of public policy has been largely similar to that adopted in the UK. The key decision is PT Asuransi and Dexia Bank. And the court there was concerned with whether an arbitral award falling under the ambit of the International Arbitration Act, where they made a finding against Indonesian state-owned entity, should be set aside on the grounds of it conflicting with the public policy of Singapore. And the court held that although the concept of public policy was not defined in the Act or the model law, the general consensus of judicial and expert opinion is that public policy under the Act encompasses a narrow scope. And the test is that whether the public policy exception, it would only operate in instances where the upholding of an arbitral award would shock the conscience or be clearly injurious to the public good or wholly offensive to the ordinary, reasonable and fully informed member of the public, or where it violates the forum's most basic notion of morality and justice. And in my view, that is an excellent test. It tallies with the approach to set aside applications in England, which require justice to cry out for correction. And that same approach is taken in relation to the public policy exception. It's extremely narrow, it's rarely applied, and that is consistent with the pro-enforcement approach. So that was all I wanted to say about England and Singapore, and I'm going to hand over to the next speaker.
Thank you, Mr. Flynn. We'll come back in the latter part. We'll discuss some parts of your presentation, but I'll hand over to the next speaker, Mr. Darius Khambata, who will be speaking on the issue of overlaps of the standard of public law in contract and arbitration law with administrative law, and also the possibility of a common international standard. Yes.
Thank you, Justice Bhat, Justice Muralidhar, judges of the Supreme Court and the High Courts, Vernon, ladies and gentlemen. The first question we usually ask ourselves at such conferences is this: is there or can there be an international legal order of arbitration? This was a vision shared by some French writers, including, of course, Emmanuel Gaillard. And one of the major obstacles in the path of fruition of such a vision is conflicting national public policies. It is 200 years, almost to the year, since Justice Burroughs made his oft-quoted passage. And Justice Bhat has quoted the first part of that passage, which is public policy is a very unruly horse. And once you get astride it, you never know where it will carry you. But there are two sentences that follow, which to my mind are even more important. And the sentences immediately following are: it may lead you from sound law, it is never argued at all, but when other points fail. And this is something we sometimes fail to keep in mind when we invoke public policy. Of course, that case, Richardson and Mellish, wasn't about public policy at all in terms of what we know of it. It was a case where there was a contract sought to be enforced by the captain of a ship who had given up his command for 4 years in favor of the son or relative of the ship owner on the condition he would come back after 4 years. Though the son only completed 2 years of that stint, the owner never brought the captain back and the captain sued for damages. And in answer to his case of, I have a clear contract, the ship owner said, well, it's never sound policy to bring back someone not on the basis of merit, but on the basis of a contract. And of course, the court said nothing of the sort. The contract must prevail. But in doing so, another concurring judgment of Chief Justice Best said a few salutary things. He said, it's not for the court to go into matters of policy. That must be left to the authorities who are best equipped to decide those questions and the pros and cons of a policy decision. And that's, of course, an issue that remains current with us today, even in our administrative law. Now, coming back to the topic, the New York Convention narrowed the scope of resistance to enforcement. It cut out the other old objection that if something is violative of principles of law of the enforcing country, which was there in the Geneva Convention. And the drafting committee is very clear that to cut this out is in aid of the pro-enforcement bias of the New York Convention. It's of interest that both India and Israel insisted that the draft say that enforcement must be refused where the award violated any law of the enforcing country, and obviously that suggestion was not accepted. And I think we've come a long way now in our act where we've defined public policy only to restrict it to a violation of the fundamental policy of law, not breach of any law. Now, public policy itself can be divided up. I would divide it at the risk of falling afoul of many commentators into 3 broad compartments. Remember, Article 5(2)(b) of the New York Convention speaks of the public policy of the country where the award is relied upon. That is the enforcing jurisdiction. So, the public policy of a country can itself be divided into 2 broad compartments. The first is the purely domestic or municipal public policy, which is always something that is invoked in aid of contracts or to refuse enforcement of contracts within the country, and therefore it's far more intrusive. It's firmly anchored on the law, the customs, the mores, and the interests of that country. But there is a narrower public policy which is confusingly referred to as international public policy, which is also of that country, but which is restricted to refusing enforcement when some essential or indispensable principles are affected by giving recognition to the award. But nevertheless, it's still a public policy anchored, albeit lightly, on that enforcing country's interests. There is a third category, which is really only the subject matter of theory and academic discussion, which is the real international public policy, or perhaps more aptly described as a transnational public policy. This is something that transcends borders and national legal systems. It is not anchored on the laws, values, interests of any one country, not even on those of the enforcing country. It is a common interpretation. Now, this is certainly not envisioned by Article 5(2)(b) of the New York Convention, nor by our statute, which incorporates that. But it is easy to think of certain circuit breakers that are in common to all countries globally, which would give grounds for not recognizing or enforcing an award. It could be human trafficking, bribery, corruption, terrorism, drug smuggling, and things of that nature. Those are the easy ones. It's much more difficult when you come to grayer areas, such as violations of law of the enforcing country, because then you have to elevate that to the status of an indispensable or core value, and therefore a violation of fundamental policy of law. Now, many commentators, including Anton Mora, who's written a beautiful book on this, has said the reason why you have conflicts of national public policies broadly is there are 3. One is every state has its own set of economic, political, religious, or social systems. And therefore, the system existing in one state will obviously not be the same as the system existing in another state. Secondly, values and mores themselves change from time to time, even within a country. And therefore, public policy has to be elastic enough to keep pace with that. And thirdly, the moment you have laws or values of a country, the enforcing country, versus the law under which the award was delivered, which is usually chosen by the parties substantively, you have to then decide whether the enforcing country's laws are so sacrosanct as to require their maintenance at all costs and without exception. Now, different countries have adopted different solutions to this. Some countries have taken the narrowest of views. France, for example, its civil code actually has a provision that says it will apply international public policy when it comes to deciding enforcement of an award. And that international public policy borders on transnational public policy. So interestingly, French judges would have to arrive at a determination, albeit just for that matter, as to what an international consensus would be on that aspect of the matter. Other countries more firmly anchor their concept of public policy upon their domestic system. So for example, Germany uses the language, the basic principles of German state and economic life in a manner that is mandatory and outside the party's scope of action. Russia refers to the basis of economic, political, and legal systems of the state. And of course, you then have countries like England, which are far more restricted, and as Vernon has told you, Singapore and India set it at the other pendulum extreme of unconscionable matters, extreme circumstances, those which shock the conscience. A term which is a little subjective and dangerous because it depends on whose conscience you're dealing with when it comes to shocking them. But be that as it may, I think a very good example of how national courts could introduce narrow standards comes from a very early American decision. One of the earliest American cases on enforcement after the US ratified the New York Convention. And that's the famous Parsons and Whitmore, the US Court of Appeals, Second Circuit. That case was a case which might find echo in today's times. It was filed by an Egyptian company suing an American construction company for non-performance of a construction contract. The Egyptian company had got an award for damages against the American company. But the non-performance was because the 1967 Arab-Israeli war had broken out. US and Egypt had snapped diplomatic ties, and in fact the US State Department had issued an advisory advising all US citizens not to have commercial relations with Egypt. So the construction company said, I just couldn't go ahead. Now it's commendable that in those circumstances, when the award came for enforcement to the US court enforced that award. And it did so in these ringing terms, and I quote, that the general pro-enforcement bias informing the convention points towards a narrow reading of the public policy defense. Additionally, conditions of reciprocity, considerations given express recognition in the convention, counsels courts to invoke the public policy defense with caution, lest foreign courts frequently accept it as a defense to enforcement of US awards. Enforcement of foreign arbitral awards may be denied on this basis only where enforcement would violate the forum state's most basic notions of morality and justice. These are words that we have now incorporated in our definition of public policy, both for Section 34 as well as for Section 48. And then it made another very telling point. The court said in equating national policy, by which it meant government policy, with United States public policy, the appellant quite plainly misses the mark. To read the public policy defense as a parochial device protective of national political interests would seriously undermine the convention's utility. I do ask myself that in today's climate, however, what if a party obtained an award, either for damages or for specific performance, to enforce a contract, to manufacture spare parts and sell them to Russian purchasers and when those spare parts were to be used in Russian armaments. Would a US court enforce such an award today based on the same principle? Or would sanctions and other legal bars to completing such a contract kick in? Now, India has by and large adopted a narrow view of public policy. Of course, the locus classicus is Renu Sagar. And that was given under our Foreign Awards Act. By the way, India was one of the first countries to ratify and incorporate the New York Convention into its law. That was way back in 1961. And Renu Sagar held that the phrase public policy of the country in the New York Convention must mean something more than the contravention of substantive law of the enforcing country. And it set out 3 criteria. It said it's a narrow public policy. We can't apply the same public policy as we apply to domestic disputes because foreign disputes and transactions have less immediate impact on our system. And it said we would restrict that public policy to 3 areas. And the 3 areas were the fundamental policy of Indian law, the interests of India, or justice or morality. And these 3 areas in some form or another have continued over the years in Indian judgments. We had one detour along the way in the matter of Fulton exports, where the Supreme Court applied the phrase public policy of India in a broad manner and incorporated all the objections which could be taken to domestic awards into the matter of enforcement of foreign awards, including by that time the saw pipes intrusion of patent illegality. So it became an extremely broad and intrusive review for enforcement. But, and this is where our system really scores, in a few years, the same Supreme Court, and indeed the same judge, said, no, we were wrong. And that is a great self-correction of a common law court. They said, no, we were wrong. You cannot go into merits. You cannot have the same standard to test enforcement of a foreign award as you would use for a domestic award. And it therefore unequivocally accepted the dualism that Renu Sagar had introduced. That was in Sri Lal Mahal. And since then, our courts, especially the Supreme Court and some high courts, have been very vigorously pro-enforcement. In Vijay Karya, for example, our Supreme Court held that every violation, even of FEMA, was not one which would breach the fundamental policy of Indian law. And it defined that as the core values of India's public policy as a nation, which may find expression not only in statutes, but also time-honored, hallowed principles which are followed by courts. The Bombay High Court in Noble Resources characterized it as the basic and substratal rationale, values and principles which form the bedrock of laws in India. So these are very, very strict tests. Now, as I said, we are a country that introduced a definition of public policy into our statute in 2015, a definition which is not found in most other statutes and is not found in the New York Convention as well. And that definition was a refined form of the 3 Renu Sagar principles, though we didn't enact one of them. The first, of course, was that the making of the award was induced or affected by fraud or corruption or was in violation of the confidentiality provisions. The second is that it must be in contravention with the fundamental policy of Indian law. And the third, it should be in conflict with the most basic notions of morality or justice. The third first, that's straight out of Parsons and Whitmore, the same expression. So a very restricted review on grounds of morality or justice, which are subjective terms. The second was a tightening up of the law already laid down in Renu Sagar. And the third criteria that Renu Sagar had introduced, interests of India, was omitted completely. So we have a very tight and focused definition. Now we all know that in between there was a bit of a risky detour when our courts started to introduce administrative law concepts into arbitration, like Wednesbury unreasonableness, irrationality, and perversity. Now these are concepts which apply under administrative law only because administrative law is concerned with the conduct of governments, of authorities that act under the Constitution or under statutes. And they are required by law to act reasonably and to discharge public functions and duties. This is totally different from arbitration, which is a private contract where party autonomy rules and where 2 parties agree to be bound by the decision of an arbitral tribunal. The test of perversity itself is a difficult one to apply in arbitral law when you also have the principle that merits-based review is prohibited. Take the definition of perversity. Coming to a finding of fact based on no evidence at all, relying on irrelevant evidence. Yeah. And the third, not relying on relevant evidence. The latter two would definitely require some peripheral merits review, which is therefore an intrusion on the principle that you can't go into merits. Now, the question is, all these differing standards, is it desirable and is it an objective to reach a unified global standard? And perhaps the answer is no, because that would undermine the very basis of the New York Convention, which recognizes diversities of public policies. The ILA, International Law Association, attempted a definition, curiously at its conference in Delhi itself, where it sought to put down certain basic notions of this public policy. But I don't know whether that definition, even that definition, can really be exhaustive of all the public policy exceptions. So today we have the New York Convention model, which our Act has incorporated. It stood the test of time. It's like the North Star of public policy objections. It obviates cases like Putra Bali, where the French court, not fettered by the New York Convention, but applying its own rules of procedure, actually gave enforcement to an award which had been set aside by the English court on the ground that an award was an instrument of an international legal order. And we have the heavy metal case in China, where a US rock group performed in China and they were into heavy metal, and that required drinking, smoking, rolling on the floor and singing. And the Chinese court said that performance of heavy metal music, and I quote, was against national sentiments and contrary to the social and political interests of China. So that's the other extreme. Fortunately, that can't apply under the New York Convention nor under our laws. I end with this, that the disputes and problems we are going to face in the future are going to be of an entirely different character to those that have hitherto been faced. We are going to face public health and pandemic claims. We are going to face climate change claims. Genetics and new technologies, space and planetary exploration are going to throw up new disputes. All these disputes will necessarily involve some aspect of sovereignty and national interests. But the solutions to these problems are going to have to be global. No one country can impose its own policy on these solutions. And therefore, today we have the New York Convention, the most successful convention, and it embodies Lord Denning's retort to Justice Burroughs that with a firm horseman in the saddle, public policy can be controlled. So I leave this house with the question as to whether this unruly horse can be tamed by international arbitral communities and by these conferences such as these, just like Alexander tamed Bucephalus. Thank you very much.
Thank you, Mr. Khambata, for a very comprehensive view of the, how shall I term it, as the ebb and tide of public policy, the way it has played out in India. And just to give, a context, our law deleted the expression interest of India and also brought in this conflict with the most basic notions of morality or justice. So in that sense, there is some kind of synthesis we have achieved. Now, with that, I will now request Justice Muralidhar to make his presentation on the discretion by judges, probably one of the most important topics of today. And also, he would be speaking on fraud.
Thank you, Justice Bhat, Mr. Flynn and Mr. Khambata. The judges of the Supreme Court and the High Courts present here, a wonderful audience of lawyers and law students, who I'm sure are learning a lot listening to these wonderful presentations. Justice Bhat was very meticulous about this particular session. So before he left for his recent visit, we had a conference, Mr. Flynn, Mr. Khambata and I with Mr. Bhat, Justice Bhat. And then we were talking about what we should be talking about. And today again we met around the table in the speaker's lounge. And Mr. Khambata was very frank. He said, I think I'm over-prepared. But I must tell Mr. Khambata that his preparation was excellent. My only grievance is he's taken away a lot of my lines, but that's not a problem. Mr. Flynn stuck to the script that he had explained to us what he was going to talk about. I was basically without a script. So I will start like this. I have a problem with the title. I think horses are not unruly at all. Horses are fine. I think people riding the horses are unruly. So, please. So, judges are waiting to find out, and even still waiting to find out in India, what is all this public policy debate about? I think Mr. Khambata was absolutely right that there is a tendency, which was warned in Parsons and Whitmore, for judges to become parochial, because you're enforcing an award in a jurisdiction where the judge hearing the case is molded by that jurisdiction. He's molded by the values, the culture of that jurisdiction. We don't realize how much it matters. It matters even in domestic contexts. I'm sure Mr. Flynn may not be aware, but everybody else in the audience is aware about the tensions about interstate water disputes in this country. Those are also tribunals that decide that. And all the issues of sovereignty that you spoke about, we have state sovereignties here. One example, a standing example, is the Ravi Vyas Sharing of Waters Award, which simply could not be enforced and still cannot be enforced because of severe, strong positions on state sovereignty. So when I was going through the literature, when a judge is faced in a particular jurisdiction with the issues that matter most to the people in that jurisdiction, will the judge be able to stand up to it and say, no, I'm still going to enforce the award, no matter what you think about the morality of this award, of justice of this award, which is why I was amazed to hear Mr. Flynn talk to us about Alexander Brothers, where the judge was very strong and said, no, I am going to enforce this award, come what you may, whatever you may think about the public policy implications of this. But there is a serious issue, as Mr. Khambata was pointing out, of the justice and morality issues, which has now come into the law. And it's been qualified by two adjectival words, most basic notions. Now, what are these most basic notions? And I would dare say, although we've incorporated Renu Sagar's dictum, that when we say public policy, we mean public policy of India, I don't see a difficulty in aligning that domestic law of India with the international law. We've been compelled to do it in other spheres. For instance, our notions of fundamental rights. So we are signatories to the International Covenant on Civil and Political Rights, on Economic and Social Rights, and we have, for instance, the National Human Rights Protection Act, where the domestic law is expected to be aligned with the international law. Likewise, since we are signatories and we adopt the convention law and arbitration, and we've in fact adopted the unilateral model, even for our statute, I would dare say that when we talk of these notions of, most basic notions of morality and justice, I think we should be expanding our horizons, not narrowing them, expanding with a view to adopting a minimalist approach. The two basic approaches in arbitration law, one is what's called a maximalist approach, the other is the minimalist approach. Classic example of minimalist approach is what is happening in England and Alexander Brothers. It is a minimalist approach. What happened with us in saw pipes, in ONGC versus Western Gecko, and maybe most recently in Elementa, is the maximalist approach. There's always a tension between the maximalist and minimalist depending on at which stage of the arbitration proceedings you are in. And that takes me to a very important aspect of the morality. There was a mention by Mr. Khambata of kinds of things, of transactions, which we would not easily accept. For instance, you go on the darknet, you've entered into a transaction for supply of drugs, and you want the enforcement of an award, which awards you the money for the purchase of the selling of those drugs. How would you enforce it? Would you enforce it? Would you bring in the public policy doctrine? Kickbacks, and these are real cases. I'm sure Mr. Flynn will enlighten us on those kickback cases. I think Westacre was a kickback case, where you are helping people purchase arms in country A, and commissions are agreed to be paid. You're facilitating those deals, and you're calling in on those deals and saying, where is my commission? I helped you buy these arms, where is my commission? There's an award pronounced. How will you enforce the award? And then there are regime changes issues. The award, the contract is entered into, the award is pronounced when a certain regime is in power. The regime changes. The court, domestic court might say, the public policy of this country has changed. Can it say it? So is this public policy immutable, or is it so flexible that it will become uncertain? And then what does it do to international relations, international commercial relations? So this is a real issue before judges. So judges have to be molded, I believe, in addressing these issues in a wider space where there's a greater exchange of thoughts and ideas and greater exchange of judgments of different jurisdictions. Otherwise, we might become very parochial and tending to be narrow and adopting very comfortably a maximalist approach, which is what happened in ONGC versus Western Greco, where we suddenly borrowed all your administrative law principles into arbitration law and to say I can interfere. Having said that, for judges, and we were discussing this, we broadly see the public policy spectrum itself as substantive issues and procedural issues. If you look at 48 itself, Section 48 of our Indian law, the Arbitration Conciliation Act 1996, you will find that there are procedural elements, not adequate notice of the arbitration. I'll just read that. That's right, 48(1)(b). The party against whom the award is invoked was not given proper notice of appointment of the arbitrator or of the arbitral proceedings, or was otherwise unable to present his case. A very common ground, which we find very often, particularly if the arbitration is taking place outside the country, which very often it does, and you simply cannot make arrangements to have representation. And then you have the substantive elements, which is what explanation 1 is about. The making of the award was induced or affected by fraud or corruption. It is in contravention of the fundamental policy of Indian law. It is in conflict with the most basic notions of morality and justice. So we have the procedural grounds and you have the substantive grounds. Judges exercising discretion, and I'm sure many of my colleagues in the Delhi High Court will agree, when procedural grounds are presented by us, before us, we find it fairly easy to determine that. For instance, through the transcripts, I remember in one case, transcripts were shown to the court to say how one of the members of the arbitral tribunal dominated the whole arbitration. He would not allow questions to be, completed. He would speak most of the time. And fortunately, since there was a transcript, you could actually see what was happening. And you could determine whether the proceedings themselves were fair or not. We've had instances of 3-member arbitral tribunals, 2 members getting together and shutting out the 3rd member altogether. So these are live instances that we have of procedural irregularities resulting in unfairness of the entire procedure. So two such universally accepted notions of what could constitute violation of public policy is the impartiality, the lack of impartiality of a tribunal. So that is certainly something that across jurisdictions, they do accept, could be a valid ground to resist enforcement of an award to say that this was not obtained with a fairness of procedure. I want to pose a question, and I'm sure Justice Bhat will be very interested in this question. When we say public policy of India, does it include the constitutional law of India? For instance, Article 14 talks of equality of arms, like equal protection of the law, equality before the law, and it's not confined to citizens. Article 14 is available to everyone. So even a person seeking enforcement, today you have, because of your international relations, every day it's a changing scenario. In the war with Russia versus Ukraine, countries are having to take sides, some struggling to stay neutral. So let's say that it's changed in a way that you look upon this party and you assign to the party, if it's a company of country A and your country is having a problem with that country, you assign, you attribute to this party before you happens to be a company incorporated in that company, in that country, the same element of hostility. Then you say, should I be dealing with this company at all? Now as a judge, how are we supposed to deal with this? Do we allow those sentiments to prevail, or we take the strong lady judge in England, Alexander Brothers, who says nothing doing, I have an arbitral award before me, I'm going to enforce it. So one is international relations, and how much are judges aware of the implications of what they decide? It will be very easy for me to say in a challenge to an award or a resistance to enforcement to stay the enforcement of the award unconditionally. What does it mean internationally? What does it do to international relations? What does it do to confidence that if I get an award, it will get implemented? I must quickly shift to the element of fraud now because I was asked to speak on it. The most recent example of the demonstration of fraud is the case of Antariksh versus Devas. Antariksh is an arm of the Indian Space Research Organization, and former employees of ISRO got together to incorporate this company called Antariksh. These facts emerged later. It emerged later that they managed to get favorable terms for allotment of a spectrum by Antariksh to Devas. The contract is entered into. So when in 2011, the Indian government suddenly decided that this contract cannot go through and rescinded the contract. It literally happened overnight. Naturally, there were arbitration claims raised because it was governed by a bilateral investment treaty with Mauritius. So we've had 2 BIT awards and a 3rd ICC award. So you have 3 international awards, foreign awards, which have gone against Antariksh. While those awards are seeking to be enforced, the Indian government applied for and got Devas, which was the party successful in the award, wound up on the ground of fraud. They were able to show the Indian courts that the entire incorporation of Devas and the award of contract, that is the underlying contract itself, was vitiated by fraud. And it's been upheld up to the Supreme Court of India, the winding up of that company, which has suffered the award. So a very interesting dimension comes up about this determination of fraud. In fact, when we were discussing, the question that arises is, I am resisting enforcement of this award, saying it was obtained by fraud. Now, how do I prove it? How should it be proved? And in what forum should it be proved? Should that be another inquiry? In fact, the English judge responded by saying, finality is also an element of public policy. She also responded by saying that we can't afford to have an inquiry at the stage of enforcement. But I don't know whether in India we will be prepared to adopt that approach, particularly in a case instance like this. But the question will still arise, which is the forum which has to determine fraud? Will it be the court before which the enforcement is being sought, or will it be some other impartial, neutral tribunal? I bring up this notion of impartiality because of the tendency to be parochial, the tendency to get idiosyncratic about enforcement, particularly when we say that this has something to do with sovereignty, it has to do something with the interests, although of course, as Justice Bhat was pointing out, we've removed that category in the definition of public policy. So these are real issues before the court, and I don't know as judges whether we're fully equipped to deal with this complexity of issues when we're faced with enforcement of foreign awards. I think, I hope I haven't exceeded my time. I'll leave you with those thoughts and we'll come back. Thank you.
Just taking upon what Justice Muralidhar said about the applicability of public law, especially constitutional law, in the context of investment treaties and investment treaty arbitrations. A very interesting, topic. And there are 4 disputes which were resolved through awards, investment treaty awards, that conflated these issues of rights to water and constitution. Very interestingly, where the 3 of the investment treaty arbitration resulted in the upholding of regulatory measures by Argentina, where the concessions were given to Spanish and US companies for 30 years. But there was a water emergency that led to some emergency legislation which curtailed those contracts. Argentina was sued, and interestingly, each of these tribunals upheld Argentina's claim and also applied Article 5.1 of the International Covenant on Economic, Social, and Cultural Rights. So it conflicts a lot of things that you spoke of. Fraud is a very interesting thing because we have entered a nascent stage where in a couple of judgments of our Supreme Court, the court has emphasized that fraud needs to be, where fraud is, it involves complicated or complex questions that needs to be tried by civil courts. But coming back to the main issue, Mr. Flynn, how would you, I'll take you back to your main presentation. Soleimani gave us one idea, that if the award, the tribunal decides that the award is contrary to the host country's laws, then possibly it can face resistance in enforcement. But how do you explain the approach? There are obvious differences, but how would you explain the differences in the other 3 cases, Westgate, for instance, or Dalla?
I just want to say a couple of words about that. Before I do that, I think there is one important distinction, and that is a distinction between public interest and public policy. And I think that's extremely important. On a day-to-day basis, you can get differences in public policy when a government changes. A public interest is the interest of the state in providing its services, hospitals, and so on. In my view, a pro-arbitration approach does not allow a state to say that we don't want to have this award enforced because we can build hospitals instead of paying up under the award. That's an issue of public interest, not an issue of public policy. The public policy question is one addressing the question is whether it's so egregious that elementary notions of morality have been transgressed. And I think it's very important to draw a distinction between public interest and public policy, and that's often missed. The other issue related to the question is that it's often easy to align issues of substantive jurisdiction and setting aside the award. No one has really addressed that issue. It's really fundamental. And it's fundamental because consent is the touchstone to any arbitration. It is the foundation of the arbitration. In England, the position since the 1996 Act is that we have incorporated by statute the civil law concept of competence, which I'm sure is familiar to all of you, but it's often misunderstood. The doctrine of competence is an order of priority. It's a civil law approach, which means that the arbitrators decide their jurisdiction first, but it doesn't stop there. It goes to the court next. And the English approach is, adopted by many common law jurisdictions throughout the world, is that if there is an attack on the substantive jurisdiction, the arbitrators decide, but the court decides that matter on a full rehearing basis, not a review basis. And that's very important because the challenge is not limited in any way. It's not limited to fraud, it's not limited to anything. I I know this because I did the first case under the Act when I was very junior, where I had a 5-day trial before the arbitrators, and I submitted to a commercial court judge that I could do exactly the same thing, have exactly the same trial, with exactly the same witnesses, asking exactly the same questions and same disclosure. This was unheard of before the Act came into force, but that was allowed and improved in DAW. So it's very important to draw this distinction between cases which do not affect substantive jurisdiction and those that do. Those where the substantive jurisdiction is affected, i.e. the arbitration agreement itself, are subject to a full rehearing. So they can be set aside and challenged on the basis of any argument, breach of contract, or whatever arguments you have. That can go to that issue. That's a distinction that's often missed. And that doesn't encompass the Solomenia more limited grounds for challenging at the enforcement stage. And even at the enforcement stage, the English law position is if it's governed by a foreign law and the foreign court of the seat does not apply a full rehearing test, only a review, there's no issue estoppel, and the enforcing court is able to review whether in fact there was agreement or not. So that's a very important distinction to cases where there's no challenge to substantive jurisdiction.
Thank you. What are your thoughts, Mr. Khambata?
I think, I think this is an issue that is going to come up sometime before our courts and the Supreme Court probably, because as we were discussing, Section 34 and 48 for that matter don't expressly address the issue of jurisdiction. So if there is a finding of jurisdiction under 16 by an arbitral tribunal with full evidence and full arguments, what is the approach of either the challenging court or the enforcing court when that award comes up before it? Can it fully review those findings and evidence like in a first appeal? It certainly can't take its own evidence because, as Vernon says, the provision in England, Section 67 is different. But can it conduct a full review, or is it limited by the constraints of Section 34? And in which case, sometimes it becomes very difficult, and I empathize with the judges because it's very difficult to fully decide a question like this without going into questions of fact sometimes.
What would you say, Mr. Flynn? There's another Suleimani which was decided in 2023 that dealt with this issue of jurisdiction, didn't it? How does it, throw any light on this? Because the argument they made there was that it was a consumer dispute where it went in for arbitration. And I think the unsuccessful party said that this was an excluded issue. Now, possibly that's a key here to the debate that Darius is raising. What are your thoughts on that?
I don't know what the Indian law position is, but certainly it's because it's such a fundamental issue. It seems to me that if you decide jurisdiction incidentally, i.e. render an award which implicitly takes jurisdiction, that in England certainly that would be subject to a full review by the courts.
So essentially one would look at it like this, that the facial part where jurisdiction is lacking, where for instance there's an exclusive tribunal which has jurisdiction and then you have an arbitration on that. So I suppose that would be a per se case where we would say that this is contrary to public policy, right? So that would be probably a gateway. But the question is, how far do you go? Yes.
Can I?
Yes, please.
So we made a small distinction between the challenge to an award and the resistance to enforcement of an award. And this change happened in 2015. So we introduced a provision in Section 34, which is the challenge provision, subsection 2, capital A, which says like this: an arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of the award. And yet the proviso says, provided that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. So this erroneous application of the law, does it touch on jurisdiction? And if it doesn't, That's the former part, that is patent illegality. So can you argue that an error of jurisdiction, and not error in jurisdiction, anismonic error of jurisdiction, is actually covered by the expression patent illegality? And you could also argue that since this is absent in section 48, we will not allow even an error of jurisdiction to be a ground for resisting the enforcement of the award. I would like to pose this to both of you.
I think just to take the idea further, I think there's the 2016 amendment explains it further by saying, by an explanation, that for the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if A, B, C. And then the second explanation, for the avoidance of doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits.
Correct.
So, can I just have a minute to,
yes.
I think Justice Bhat has put his finger on it, because the explanation says no review on merits. What Justice Muralidhar also read was no re-appreciation of evidence. So if these tests are applied to a review of the finding of a tribunal on fraud or on any such, or on jurisdictional issues as a whole, it becomes very difficult for a court to actually reach a conclusion sometimes on that issue. One possible way is to say the whole issue is completely outside 34. 34 predicates that you will have an arbitral tribunal with jurisdiction. But I don't know where to fit that in to the Act, which is modeled on the UNCITRAL model law.
I agree. I think it can only properly be read on the basis that that section predetermines such jurisdiction. It can't. There's an issue of principle, which is the arbitrators can't pull themselves up by their own bootstraps. So take an example where the arbitrators make no errors of fact and no errors of law, and they decide they have jurisdiction. Why is the party who says that they're not bound by an arbitration award, which they said they never agreed to? So ultimately it must rest with the court. So somehow or other it has to get to the court to determine jurisdiction. And I would say, following the English example, that would be on a rehearing basis without limit, not a review of or providing any deference, however eminent the tribunal is. It needs to be done on a completely de novo basis by the court.
So it's some kind of a residual jurisdiction which the English courts always claim.
Yes.
But coming back to your point, Mr. Khambata, does 16 give you any clue? Because 16.2 talks of tribunal's jurisdiction. And interestingly, 16.6 says a party aggrieved by such an arbitral award, and this is deemed to be an award, if it is accepted, may make an application for setting aside such an award in accordance with 34. So impliedly you're getting this idea into 34, even though expressly there is no mention of jurisdiction.
In fact, the Bombay High Court is held exactly with that.
I remember it because in one of the judgments I had to deal with in Delhi, I too held that. Yes, I think we have just a little time for about 10 minutes, maybe 5 to 10 minutes for questions. Anyone in the audience wanting to put any question to the panelists?
I have a question for the audience, because this is on discretion of judges. So one judge, a single judge in any of our high courts, can set aside an award given by 3 arbitrators. So should there be a rule that it goes before a bench of at least 3 judges?
Yes.
My question is that when we are refusing to enforce or recognize a foreign arbitral award, it says
that, please introduce yourself.
I am Ramesh Kumar. I am working as a law officer in Maratna PSU. So the question is, our section 48 says that if making of award is induced or affected by fraud or corruption. So when you are enforcing the foreign award, would you be saying that whether award was obtained or procured through corruption or fraud, or you will go into that whether the contract itself was procured or obtained through fraud or corruption?
I think the statute is reasonably clear that it's the award that has been procured by fraud or corruption, or the proceedings. Because if it widened it out to deciding all cases of fraud, then you would effectively be allowing the challenge court or the enforcing court to do a full review on merits again.
I only have one rider to that. If you look at the judgment in Antariksh versus Devas, the Supreme Court, in the last paragraph, while they say that the NCLAT was fully justified in winding up the company, they said since this entire thing is vitiated with fraud, anything done pursuant to the constitution of that incorporation of that company and contracts entered into by that company and all awards, everything is vitiated. So they just add that saying it's the underlying contract itself which is fraudulent and therefore the award also becomes fraudulent.
Fraud unravels all. Yes. Anyone else? Yes.
I was just wondering whether you could fit in the challenge under 34 2A4 or 34 2B1, the jurisdictional challenge and the fraud challenge.
Yes. Would like to answer.
We have the advantage of two eminent senior counsel here.
It would be a bit of a stretch, but there are some judgments which seem to fit them into jurisdiction and subject matter.
So Gaurav was speaking of 34 to A1, is it?
A4.
A4, I'm sorry.
And 34.
Yes, but A4, you're absolutely correct, but that is arbitrability. Dispute not contemplated by or not falling within the terms of submission to arbitration or decision on matters beyond the scope of the submission to arbitration. What if you have a vanilla case where a party says, that's not my signature on the contract or on the arbitration agreement, it's forged. I never agreed to go this contract or to the arbitration. That might not fall under A24. And that would probably fall under patent illegality or perhaps even in some respects under public policy, because if the case is strong. But the question is, if the tribunal has found that it's a valid signature, and it was a signature, then where does that leave the court?
Could we not put it in 2B1, subject matter not capable? You know, fraud vitiating everything. Analogy with consumer disputes and such public policy.
I don't want to make any further comments on this aspect.
So may I be permitted?
I object, Mr. Khambata can't reserve judgment.
Yes.
So my name is Mohit Jolly. I practice in the Delhi High Court. So my question is twofold. I'm sorry for asking a two-part question. The first thing is that the first principle of arbitration is party autonomy. In that, where a party has chosen a foreign jurisdiction, should it be allowed to take the defense of public policy where it may not be in contravention of public policy of the country where such a decision is taken? And especially in the context, the second part of the question is especially in the context where arbitrations, Indian parties are now permitted to choose foreign seated arbitrations. So there may not be a conflict of public policy in the state passing the award. However, when it comes to enforcement, should those parties be permitted to take the defense of a public policy?
I think that the language of Article 5(2) is clear on that. Where you seek enforcement, the public policy of that country is what is an issue. So I don't think that's a matter of debate. The question is, what is public policy, of course, is.
I think the other answer is you're submitting to a jurisdiction which you think will be fair. You don't anticipate, like for instance, the bias of one of the arbitrators. Suppose it was discovered much later. Would you be precluded from putting that forth? Merely because you submitted to the jurisdiction. So you can't anticipate how the arbitral tribunal will decide, what it will decide. So that's how I think the New York Convention permits this to be raised in defense.
I just add that it does give rise to another question, which is that some states are enacting laws in relation to sensitive areas which make unlawful an arbitration agreement in that particular respect. So if you subject yourself to the law of that country by choosing the seat there, you'll find that the arbitration agreement can be invalid, and certainly it would make enforcement difficult because it would be contrary to the public policy of the enforcing state.
Anyone else?
Nobody's answered my question.
My name is Rohan Chawla. I'm an advocate based in Delhi. My question was that the 34 provides that the making of the award was procured by fraud or corruption. And what if we realize that the fraud or corruption was after the making of the award, that the facts that came to light came after? Would that enable the 34 court to enter into some sort of trial to prove that fraud? Because just on pleadings it would not be enough.
That's a very interesting question, because you would expect that the making of the award and the fraud which vitiates the making of the award is something that would come to light after the award is made. But then we have, perhaps this is a sui generis kind of case, we have not yet come across where the courts have had to try it. One suspects that we yet to see those days, and if and when such a challenge is mounted, perhaps, well, if not in 34, then 37, some kind of, we don't know. Perhaps it's possible. Perhaps it's possible.
Just say, from an English law perspective, this was addressed in Westacre, and you have to show that the evidence of fraud was not available to the party at the time of the arbitration hearing. And you also need to show that the evidence is so strong that would reasonably expect it to be decisive of the issue at the hearing. So it's quite a tough test.
Hi, this is Ganesh Chandru. To answer your question, Justice Muralidhar, your question was a 3-member international arbitral tribunal, a matter coming before an Indian court. Instead of single judge, should it be before 3 judges? I think perhaps it should be before 5 judges.
I also wanted to answer Justice Muralidhar's question. I think if you have judges of the caliber of either Justice Bhat or Justice Muralidhar, one is more than enough.
Disallowed on the ground of bias.
I'm J.R. Midda, former judge of this court. You see, the term most basic notions of morality or justice are very wide terms, and they have been interpreted only in one case of associate builders, where the Supreme Court said what pricks the conscience of the court will be said to be against most basic notions of morality or justice. I had the occasion to apply this doctrine in 3 cases, but there is not much case law or guidance on this. So would not this wide interpretation, which is what pricks the conscience of the court, is so wide term that it can be interpreted to go to any extent. So to my mind, there is need of some guidelines on this term, most basic notions. Although there was not much guidance, even in associate builder, they just gave the interpretation, but not much on the application of this doctrine to the facts. So what is your view on this? How do we deal with it? Whereas 34 is very narrow on one hand, but on the other hand, the most basic, what pricks the conscience, such a wide door that where anything can be permitted to be incorporated. So how do we deal with this? There is no judicial guidance on this or precedents on this. And in the 3 cases which I had the occasion to deal with it, there is not much case law on this, how to deal with it. So is not an unguided, wide discretion on this term. Thank you.
You're right, there isn't, certainly in English law. I mean, this test mirrors the test in England on serious irregularity. So if you look at Section 68 of the Act, you could go through and you could say all of these things happened in the arbitration. But justice has to cry out for it to be corrected. It's another energetic way of saying the same thing, which is essentially that it's not the ordinary case, it's an extreme case. It has to hit the court as extreme. So that is really the test, and that's the way but it's not simply about certain things happened, it's that they're so extreme that they justify interference by the court. So it's a shorthand, really, of explaining that the test is there, but it's a very high bar. And so that's really the judge is being told this can only be applied in very extreme cases. Is this truly an extreme case? And that's what it really comes down to.
This has not much developed in our country. This term has not been much interpreted. In very few cases, when in the 3 cases which I invoked, there was not much case law on this, except associate builder, which also gives only a definition. But this case law also needs to be...
I think the reason is these are only adjectives. The statute doesn't use these terms. It refers to, right now I think it's basic notions of public morality, etc. Most basic notions, etc. The adjective, as Mr. Flynn said, is to heavily underline the concept that the standard that you apply is a very high one. And therefore, the threshold, the bar is very high. But be very, very circumspect in invoking this. I think that's any one question. Probably we could take, yes. That would be the last, because we are out of time now.
Thanks. I'm Ishan Devan. I'm a lawyer practicing in Delhi. It might be a little unrelated, but for instance, I've come across cases where a company which is undergoing moratorium under Section 14 of the IBC, and there are arbitration proceedings ongoing. Delhi High Court as well as NCLAT, there are judgments, Jharkhand Vitri, etc., where the RP will come and say that I don't mind if the claim continues against me and my counterclaim can continue. Now, as far as my reading goes, that consent given by the RP at that stage itself is against the most fundamental public policy of the country, because something like moratorium in the IBC code, it's something which is law, and a person acting as an RP or an IRP can't really say that I don't mind if the claim continues. And then tomorrow when there's an award against it, the reasoning in a couple of judgments is that, okay, enforcement cannot be done anyway, but let the adjudication go on. If by that time the company by any chance comes out of moratorium and the insolvency doesn't go forward, and there are many provisions in IBC in which the company can come out of it. At that time, if the claim is against that company, which at the time the adjudication is under moratorium, is that something which would fit in the exception of public policy in 34, in section 34? Because I see the law developing in that sense is a little, the tangent I see is a little off.
We are looking at a transient issue of jurisdiction, and that should not be something that strikes at the root of the award which is made later. So a transient suspension of jurisdiction per se should not operate as something contrary to public policy.
But
because you are looking at an award, a possible award later, which anyway will be then, if the company goes into resolution, that will be taken into account. There is no run on the assets of the company, as it were. So I don't think we can go.
But just about at the time when the arbitrator, the tribunal is adjudicating on the claims, is it not exceeding its jurisdiction?
As I said, this is only a transient issue. How long can a moratorium exist?
Yes, that's correct.
I think with that we'll end this. I think personally, and I can speak for the those on the dais, it's been a very, very enlightening debate. And I hope the audience also found it to be so. I sincerely believe that they did. There has been some engagement with the audience, especially with Justice Muralidhar's active intervention and seeking out the audience comments. And the audience is asking to...
I hope they found us unruly enough.
You all got that.
Thank you, each of you for such an engaging session. We'll now break for lunch and be back at 2:15. For those of you who wish to see the center, please feel free to visit. We are at the first and the second floor of the same building, and we have set up an experience room at first floor in the conference room number 2. Thank you.
Thank you.
This is stolen property.